Hello and welcome to today's webinar on community use of school facilities in Minnesota. My name is Natasha Frost and I'm a staff attorney at the Public Health Law Center in St. Paul, Minnesota. The Public Health Law Center is a nonprofit organization and we help advocates, including public health stakeholders, to help promote public health laws in policy and systems change. We do legal research relating to a variety of topics, including healthy, affordable food access to active play and physical activity opportunities, and reduction of tobacco control efforts. This takes a variety of forms. As it relates to our topic today, community use of school facilities, we have done a 50-state review on the legal issues relating to community use of school facilities. So we have done a wide variety of research on what liability laws apply and cover school facilities as it relates when they open up their door for community use of school property. We've also focused on working with communities across the country on policy development, things like school board policy or state policy efforts to try and encourage and increase the use of school property by community advocates. We also have a variety of publications and do several trainings, including webinars and in-person trainings related to the topics that we cover. We do not provide direct representation, and we do not lobby. So just a reminder for today's webinar, this information is not legal advice to you, and you should consult an attorney before using the information in your day-to-day interactions related to community use of school property. So community use of school property is a really exciting opportunity for a lot of stakeholders to have a win. So what I'm talking about today is opening up our school doors so that community members, either individually or as groups like the Boys and Girls Club or the YMCA, can have opportunities to be physically active and space to be physically active. And many stakeholders can benefit from this, from a robust use of school spaces. So opening up the school for recreation has the potential to become essentially a triple win for schools, community organizations, and the community members themselves. And we're going to talk about that in further detail today. So I'd like to start by acknowledging how this work was funded. So the focus of our work to increase availability of schools for recreation, and in order to do that, we joined forces with J.O. Spengler, who at the time was at the University of Florida, and got a research grant from Active Living Research, which is a program of the Robert Wood Johnson Foundation. And our research project was to research a new liability law in Minnesota that provided liability protection for schools when injuries occur during recreational use of school property. So for the project, we developed a set of resources and completed several trainings around the state. So this presentation actually grew out of that informative research project. So there are a lot of common barriers when it comes to community use of using the schools for community use or recreation. So there's a number of direct and indirect benefits associated with shared use of school property, but the implementation of community use is now without its challenges. There are a number of identified barriers, some of which we talk about here. So there is cost. So by increasing the hours that are allowed for increased access to school property, this increases the use of the facilities, and it's logical that there would be a concern related to cost. Some of the costs that might be associated with increased hours include the maintenance, utilities, and additional staffing. So lack of funding to support the cost is associated with the utilities, maintenance, repairs, and increased custodial costs. Physical design might also be a barrier. So many schools are not actually designed for the use of activity outside of the school day. So there might be limitations with facilities or equipment that might not accommodate the needs of the users in the community. There are also operational concerns, so concerns about staffing to support shared use. And this is a common concern that was cited in our survey to school administrators in Minnesota. So staff support is really necessary to handle the shared use operations, including unlocking the school doors, providing security, handling the scheduling, as well as maintenance and custodial services. There's also been issues raised related to decision-making and scheduling. So lack of a clear decision-making process to determine who gets to use the school property and equipment can be really a barrier to enacting and increasing shared use. So it's important to have a process in place to determine who gets priority. And one example of this process could be outlined in the policies related to drop-in or one-time use versus short-term or long-term use by a community organization. So a lot of schools give priority to use for that repeated use. So many YMCAs have a scheduling priority over that one-time drop-in use by community members. This is also true for other youth-related programs. And finally, we've seen from across the country that liability and risk management is a real barrier to community use of school property. So fear of liability is a common barrier, and sometimes that's real or sometimes it's perceived. And we're going to go into further detail related to that barrier and how it relates and is kind of how it plays out in Minnesota. So there are lots of strategies for overcoming these barriers. One of the most, so the barriers listed can appear to be really cumbersome, but there are strategies including policy and legal options to overcome and really encourage and increase the use of school property. So a number of schools around the United States have successfully actually overcome these barriers. One of the key things to start with is knowing what the state and local laws are. So this includes familiarizing yourself with the state community laws and recreational use statutes, limitations on damages, and other cases that really impact that liability factor or the risk management factor. There are also ways to start working groups where you can maximize the use through community collaboration. Another opportunity would be to review the costs that are associated with community use of school property and incorporating those costs either into the use of school property, so fees associated with the use, or identifying other funding streams such as public-private partnerships or other grant funding available. And then finally, creating agreements or using facility use forms is another opportunity to really make sure that everyone is on the same page when you're working with other community stakeholders and you're opening up the school doors. And we're going to talk about a variety of different opportunities to overcome these barriers throughout today's presentation. So one of the issues that has come up across the country has been liability. So that's the big elephant in the room. People are worried about getting sued if they open up the doors for community use of school property. So we want to really start by trying to dispel or kind of talk through what is liability. So there's a lot of different kinds of liability, and there are a lot of ways that people are thinking about reduction or limiting their liability risk. So arguably the most significant form of liability that when we're talking about the school context is an injury that relates from an activity that occurs while the community member is on school property. So why does liability matter? I mean, the reality is that you can get sued when you walk out your front door for doing anything. And so I think what the school districts have shared with us through our surveys and through our trainings is that the increased access to school property can really, in their terms, increase their fear that there is an increased pool of litigants that could actually sue them. But the reality is that there's a risk around every door. So we want to review the basics of what liability is so that we can understand those legal issues involving injury and really figure out how to either see how the law protects the schools from liability, or how the liability risk can actually be minimized through risk management techniques. So the kind of liability that we're really going to be talking today is a tort. So a tort is a civil wrongdoing where there's damages that are sought from an injured party. So this presentation is going to be focused on that kind of liability risk. And it really relates to, again, having somebody come, an example would be if somebody comes onto school property for a recreational activity, is injured, so they trip and they fall. They have an injury that then costs money, so they have to go to the hospital and they have a hospital bill. and they don't have any mechanism to pay for that injury or that bill, and therefore seek reimbursement from the school district. And there are a lot of steps to this process, including there's insurance that is involved in the process. So many injuries are actually covered either through the participant's insurance or through the school district's insurance already, and so that wouldn't necessarily result in a claim going to court. And so there's a lot of steps that a lot of hoops that you have to travel through in order to get to the point where you go in front of a judge. And so in order to actually get in front of a judge, there are several elements that you have to show have happened, and these are the 4 elements. So there's duty of care, the breach, damage, and causation. And these are really complicated legal concepts, and so we're just going to cover them in really overarching, just really general terms today. So the standards for holding somebody liable really differ depending on who or what caused the injury. So typically for a person to be held liable for somebody else's injuries, an injured person must first prove that the accused had a legal responsibility to protect him or her from harm. So this is that duty of care. So I have the duty to protect you from harm. And then the injured party has to show that the accused party failed to protect that person from harm. And so that is that breach. And in fact, that breach or that failure to protect the person from harm actually was foreseeable. So they could have foreseen that injury would have happened, and that's that causation. And then finally, that there were, in fact, damages as a result of all of those elements. And so this whole issue of that foreseeable or reasonable injury, what is considered reasonable, depends on the circumstances. So a failure to act with a duty of care that is an ordinary reasonable person in a given situation is considered more commonly negligence, and there are, that's kind of what we're talking about today. And so this issue related to negligence, as can be seen on this graph, as you can see, the reasonable person standard. So when you walk out of your front door, every single person has to behave reasonably. And the example that we usually give in this scenario is as a community member, if you're walking down the street and you see somebody at a stoplight and you push them out into ongoing traffic, that is not a reasonable behavior, and you actually could be sued by the person that got pushed out into the street if they were caused any damage related to that activity. And this plays out in the school setting, but schools have a wide variety of kind of the duty of care that they owe another person, and that's where the spectrum comes into place. So what is considered reasonable can be really up to interpretation depending on the situation. So, we have this general negligence standard, which is the failure, as I said before, a failure to act as an ordinary reasonable person. And there's this wonderful example out of a case out of New York that is really kind of illustrates the steps of that process. And so that case went as follows. So there was a situation where there was a YMCA-sponsored Wellness for Life obstacle course. And so this happened on school property. And so the course involved this swinging rope where you went from a log over an imaginary pit, and in the pit there was just a flat bare dirt. And then on the other side there was a log. And so as part of this obstacle course, you had to swing from one log to the other. And the rope hung only about 1.5 feet from the ground, and then over this imaginary pit. So the plaintiff, which is the person who was injured, swung across the pit, lost her grip, and fell onto the ground. And she injured her ankle when she landed on the ground. She actually sued the YMCA for negligence, and her claim was that the YMCA should have used shock-resistant materials in the pit. So that's that kind of their failure to act appropriately. The Y's failure was based on this claim that they should have used shock-resistant materials in the pit. And so when you walk through the elements of negligence, first you have to figure out whether or not YMCA had a legal duty to the participants. And the court actually found that yes, the Y, because they brought people into to this activity, they had a responsibility to behave reasonably. Then they looked at the standard of care, And in this case, it was that reasonable, the standard of care in this case was whether or not the lack of the proper surfacing material and the level of supervision actually deviated from that reasonable person standard. And then whether or not that failure to provide that shock-resistant material resulted in the injury, and then finally the existence of an injury. So the biggest piece of the puzzle for the court was whether or not the Y should have provided shock-resistant materials, and the court found that that was not reasonable, that the dirt pit was a reasonable standard of care for the participants, and that the Y behaved reasonably. So you have to walk through all of those elements in order to actually in order for it to lose in court. But as you can imagine, walking through all those elements, going through a full jury trial can be very expensive. And so there are lots of school districts who actually just the fear of that liability, of that cost of walking through that court case can be restrictive in how they open up their school doors. So schools in Minnesota actually have a different level of care for participants who are participating in different activities that include this willful or wanton and gross negligence standard. And we're going to talk about that in a little more detail in a moment. One of the things that is really critical to understand, even if you have a duty of care for a participant, is the concept of governmental immunity. And this is a really important protection for school districts in Minnesota. And the reason for that is even if you owe somebody a duty of care, there is this concept of a governmental immunity that can protect school districts, including municipalities, and school districts are covered under that municipality protection. And the idea is that even if you did something wrong, the governmental immunity protects you from a lawsuit. And this is a really important concept, and it really grew out of this idea that the government could not be really overburdened with lawsuits and the fear of being sued based on just the day-to-day actions of government. And so governmental immunity was a way that the courts have limited how much the citizens can sue the government. And one of the important things to understand of why immunity matters is because it's important to understand that this kind of immunity is part of that risk management strategy. So when you don't start out as a school district from the point of I'm going to get sued, and instead they come through the vision of we're going to try and avoid having any injuries happen. And then if an injury does in fact happen, which is not necessarily the goal, but if there is an injury that happens, we have immunity to protect us from a lawsuit. And so in Minnesota, there are two different concepts from an immunity perspective that would apply to school districts who open up their schools, school districts who open the schools for community use of school property. So first of all, schools are shielded from from liability through the immunity in Minnesota if they behave in what is called a discretionary act. So statutory discretionary immunity protects the policymaking decisions that require consideration of a lot of different factors. So things like budget, education, and resources, safety. There's this really good example in Minnesota where a school district adopted a policy relating to whether or not kids got on a bus. And and it was the kids' responsibility to get on the bus at the end of the day. It was not the school's responsibility to get them from the front door to the bus. And they actually, the school district actually showed in court that they had they considered that as a policy decision for a lot of different factors. They wanted to increase the development of the students and taking control of something in their lives. There was a cost associated with having additional staff that actually played into that policy decision. And so they weighed a lot of different reasons to create the policy. And there was a situation in that sense where a child actually was trying to get, or was going on to get on the bus, decided not to get on the bus and walk home, and was killed in a car accident. A car hit the child, and the court found that that policy decision of having the school district made the policy decision to allow that child to walk from the front door to the bus, and that was covered under discretionary immunity. And so that is an example of an injury that occurred, and the school district was protected under this idea of discretionary immunity. And that is, again, a very complicated set of factors and often involves litigation. A much more succinct way of protection for school districts that open up their doors for community use of school property can be found in recreational use immunity, and there's two statutory provisions that cover school districts, including one that was passed in 2012, which is Section 466.03, Subdivision 23. And that provision was specifically created for school districts for when they opened up their doors for recreational activities on school property. And it's a really important tool to encourage schools to open up their doors. And so this provision provides for that immunity if injuries occur as a result from use of school property for public recreation. And school districts and other municipalities are covered by this law that was passed in 2012. And we have, the public health officer has a fact sheet that goes through the various provisions, what's covered and what is not covered. And the key component to understanding the breadth of this protection is understanding what's not covered. And the immunity does not cover in the existing duties that the district owes its employees or the public at large. And so it really links to this what's called a trespasser standard of care in Minnesota. So the school district would still face liability concerns if they create a condition, and it's an artificial condition, that is, you can see it, and it is a highly dangerous hazard. So for example, if the school district knew of a highly dangerous hazard on their property but did not post warning signs or remove the dangerous hazards, they may be found liable if somebody were to be injured as a result of this hazard. And so this is a very new law that was passed in 2012, and we don't have a lot of court interpretation on that law of how it's going to be applied. But the goal of the provision was actually meant to provide an additional level of protection for school districts when they were considering whether or not to open up their doors for school property. So there's also a provision that protects officials from immunity, and I won't go into it in a lot of detail in today's presentation, but there is a fact sheet that talks about official immunity, and it protects individuals from that personal liability if they are making discretionary actions during the course of their duties. So if it's really intended to alleviate concerns from that personal liability based on being a professional. So generally, school districts are required to defend lawsuits if their personnel are individually sued. And so this is a level of protection for those individual employees. So when you're thinking about the immunity in Minnesota, one of the things that you have to consider is what the courts are going to look at, because you still have to go in front of a judge. And immunity can be really important because the idea is that once you get in front of a judge for a lawsuit, the judge will consider whether or not immunity applies and then dismiss the case if the judge thinks that the immunity is applicable. And the courts look for a variety of factors. They look for written policies. They look for a history of accidents, and that's based on that kind of knowledge of a previous act. They look about complaints or comments about the safety concerns on the school district property, any safety inspections that have occurred in schools, whether or not there's a lot of usage in a particular area, and if there are any existing standards, either just from a general professional standards or from a professional group. Those are all factors that the courts will look at, and so it's really important as a risk management strategy for school districts to have written policies and address any sort of concerns that come up from a safety lens as soon as the school district is notified. There are also other protections for schools, including municipal tort caps, and what that means is that even if an injury occurs and even if the school district is found liable, there are limited liability exposure. There are dollar amounts per individual and per event that limit how much an individual who is harmed on school property, how much they can get from a lawsuit. Another really important tool in Minnesota is our Joint Powers Agreement. So the Joint Powers Act actually gives broad authority to governmental entities to enter into agreements and exercise some powers that are common to all parties. And so governments can actually work together and this to kind of consolidate services or come up with agreements that through a services contract where they share costs and expectations and liability, and there is a very detailed process that's laid out in the statute of how to really work together as a governmental entity related to, that shifting or sharing of liability in particular or costs associated with a particular project. And this is quite common for recreational departments at the local level to collaborate with school districts as it relates to programming and use of property for recreational purposes. So this is a very general overview of liability and the different levels of protection from a liability lens as it relates to school property and opening up school property for recreational use. But the reality is that each school district has a attorney that they should seek out to review individual facts, because each case is very, very different. So this is more of a guide, and quite honestly, the best things that school districts can do really are not about trying to avoid litigation, but they're really about avoiding the injury itself, and that can be done through effective use of risk management strategies. So there are several risk management strategies that exist in order to really avoid harm of a participant or a community member that's on school property for community recreational use. And there, the Public Health Law Center has a fact sheet related to risk management service strategies for any sort of programming or services or facilities that are made available to the community in Minnesota, and I would encourage you to take a look at our website, which will be at the end of this presentation. So one of the ideas is, from a risk management strategy perspective, is to really prepare. And preparing for the worst, I think, is one, and preparing for an event is really important. So thinking about, how to train your staff and even the participants in the activity, and understanding that there needs to be effective communication and supervision during the event. Having safety standards is really critical, and really thinking about all the different components of that preparation for the event or even for an open use of school property. And in some cases, what makes sense is to have waivers and releases signed by the participants. And this is not a foolproof way to avoid litigation, but waiver is just one way to reduce liability and actually have an opportunity for risk management. So in Minnesota, there are some protections that are provided by the courts for waivers and releases, but more than anything, waivers and releases really have the effect of making sure that the participant understands the risks, and so it's more of a training tool, an education tool more than anything. And so they understand the risks of the activity, and it's a way to communicate with the user of the property. Another, tying right into that is other forms of education. And so trying to avoid injuries in the first, creating safety rules, handing them out to all students. So if it's not in a waiver or release, just making sure that the list of the rules is either prominently posted or provided to the participants. Another great example in Minnesota is there are lots of opportunities to walk or bike to school, otherwise known as safe routes to school policies. And so in that promotion of biking and walking, there are really some key things that that the school can do to train students about, bike and pedestrian safety, making sure the parents know about helmets, making sure educating the bus drivers, for example, on what the routes are. And so it's really trying to figure out how to educate all the participants or all the stakeholders involved to try and avoid that risk of harm. Another opportunity is really good planning. There are some great examples of how you can be proactive related to an activity. So ensuring that the parking plan, for example, is really good for a community recreational event, so that there aren't limiting or avoiding accidents that can occur between an automobile and a pedestrian in a particular area, or making sure that there's enough supervision, making sure that everyone knows their role in activity. So that good proactive planning can be a really critical risk management strategy. And also just eliminating dangers. We've worked in several scenarios where just the simple, use of signage or having an event in a different location to really ensure that the safety standards are met is really critical. So thinking about, like, what are the safety standards for playgrounds or track and field or other structures? Do they meet with a national standard? And having a process in place for a regular review of those standards to ensure that whatever facility is open to the public meets those standards. Another opportunity, and a really often used ones actually in Minnesota, are contracts. So there are many schools across the states in Minnesota that use facility use forms. Or they might be called some other, joint powers agreements between two governmental entities, or other contracts, which is between two parties where they set out all the terms of their relationship. And these facility use forms are really valuable in ensuring that people understand what roles each person plays. And so, for example, if the YMCA is using a facility in Minnesota at a particular school district or a particular school facility, the contract would actually lay out what is the Y responsible for, what is the school district responsible for, and this is also a way to ensure that, maybe the YMCA provides insurance for the activity, or, the school district is going to be providing some supervision for the activity or vice versa. And so this contract really makes sure that everyone has the same understanding of the risks involved with the activity and the ways to avoid the risk. And these are often used to actually lay out who has the responsibility for coverage through insurance, or who has the liability risk associated with the activity. And, speaking of insurance is actually one of the most important things that can avoid litigation and really as a risk management tool. And insurance obviously comes into play when there is actually already an injury, but having good broad coverage for an insurance is really important when school districts are considering opening up their doors for school property. And the idea is that if there is an injury that occurs on school property, that if the participant is covered or if the school district is covered, there should be no need for litigation because the insurance should pick up the cost of any sort of injury that occurs during the course of that activity. And then finally, really good policy drafting is important, and we have developed a Minnesota School District recreational use checklist, which actually goes through the various components of a policy, and it actually frames it within the context of a school board policy rule or regulation, and then an actual recreational agreement, which is a facility use form or other form that's used by the school districts. And so understanding how to really lay out something in writing, and whether that's between just the two parties that are using, the person using the school property or the entity that's using school property and and the school district, or if it's just a general policy about how, for example, the school district is going to promote and allow for the use of their playgrounds, for example, and having that contained in the general school board policy. That policy drafting is really important for almost all of the risk management strategies that I described above, because it could be a good educator, it could be a good way of planning, it could be a way of essentially providing a waiver or release of responsibility through a written document that you provide to participants. So it's really important to use the policy drafting, and I would encourage school districts or stakeholders working on these agreements to look at our checklist for the best practices. And, given that we've done so much work in Minnesota, but we've also actually done a lot of work in this area across the country, we have several lessons learned. So we were lucky enough to work with the Minnesota School Board Association and the Minnesota Association of School Administrators, and on a project relating to the surveying of school administrators. And as part of that, we listened to the school administrators and we listened to their representatives. And there is a draft model policy, actually, that the school board puts out for school districts across the state. And so looking at that model policy, but then really honing in on how to use those contracts or those agreements to really kind of allow for some of those risk management strategies is important. But understanding that schools are often using these model policies, and then starting from those and developing specific relationships with individual school boards is really important as a first step. And also, a lot of when we've been doing this work, a lot of public health advocates who are trying to increase access to community use of school property, they really start with those school wellness policies. And in a lot of cases, it's not necessarily the school wellness policies that are guiding the behavior that's happening on the ground in the school district. And so really looking to the facility use or community use policies that exist on school boards and really looking to those forms is really important. And then finally, we've actually found that there's a lot of opportunities for growth in communicating with the public. So in our survey and our conversations with the school administrators, many of them don't have their information posted on the website or have ways to communicate with the public about what use is available for the community. And so really trying to figure out opportunities to increase use through promotion on websites or promotion through other forms or community events is really important. And that being said, I think the other big takeaway that we found is there is a cost, again, associated with community use of school property. And so figuring out ways, as from the community lens, figuring out ways to support the schools in opening up their doors or funding projects from the very beginning through local levies for school districts, and figuring out ways for public-private partnerships really can encourage schools to maximize the use of the schools for community use. But there is a cost associated with that use, and understanding that is a really critical component. And then also, what we found in several different communities is community engagement is really, really important, and it starts with accessibility. So we talk about the school district as being a critical partner in ensuring that everyone has the opportunity to be physically active, and because the schools themselves are compliant with the American with Disabilities Act based on federal law, they are really, really important partners in ensuring that people of all abilities have places to be physically active, but not just necessarily accessibility from the perspective of people with differing abilities, but also people who may have language barriers or people who might have other, transportation limitations. So trying to figure out how how you can maximize the community use of school property from that accessibility. So ensuring that signage is translated into languages that people who are not necessarily, people who are not native English speakers might have other opportunities to understand how to use the school property figuring out how to promote a wide variety of activities on school property. These are all things that the school districts can do to maximize that community engagement and really maximize use of school property. There's also the design itself. So design really can be overlooked, but it's an important element when the school districts are thinking about inviting the community to be on school property to be active. So when schools are renovating school playgrounds or school gym facilities or track and field, thinking about what that could look like and how the community use component fits into that renovation is really critical. Safety can also be a big concern. So we have some design elements where, things about you can have safety with signage, you can have safety with figuring out how to use the equipment, like in a weight room, really ensuring that even safety as far as other weather factors, ensuring there's enough shade in a recreational area on a school property for weather changes or differentials in weather. So those are really important considerations from a safety lens that schools should be considering when they're addressing the community's school property. And then finally, really studies have found that without really intentional planning and programming, there is a limitation on access to community or access to school property for community use for recreation. And so thinking about opportunities to partner with local organizations and local nonprofits to provide programming on school property to make sure that all community members have the ability to recreate is really critical. And so finally, we had, as I mentioned before, the Public Health Law Center has developed a series of materials related to community use of school property for Minnesota specifically, but we have other resources for community use in other states such as Washington and Missouri and Wisconsin, just to name a few. And so I would encourage you to take a look at our website, which is located here, and identify any other healthy eating, active play, or tobacco control policy practices and resources that could really help support your community effort. And with that, I would like to thank you for listening to this webinar and have a wonderful day.